Welcome everyone to our weekly webinar. Super grateful that you continue to return. We're going to jump right in and provide some value. Before I do, our team has received a number of questions about some of the comments we've posted in Mitigation Arc, including a free link if you'd like to use it. Michael Santos, my partner, our team members created a new service to help advance our advocacy efforts. So it's a daily mastermind with Michael that he leads 7 days a week, usually at 1 p.m., could be 2 p.m. or 3 p.m. You get a daily reminder. All of our courses from sentencing narratives to release plans, PSR, RDAP, what to know about government investigations are there. So if it's something you'd like to try at no cost, we can put a link here. And there's also a link at the top of the school community. It's a wonderful spot for you to learn, get more information from my partner, Michael Santos. So go ahead and give it a shot if you have interest. As a reminder, this webinar is recorded. We no longer put them on YouTube for a myriad reasons, in part to reward you for joining our community and coming here every week to learn. To the extent that we can give you our free resources, we're going to. So if I reference things in this webinar, I'll ask Scott or Patty to post them for you to refer to them. This will be posted in the webinar replay. With that 90-second quasi pitch for Mitigation Arc out of the way, let's jump right into an interview with my good friend and lawyer, Nicholas Kaizer. Quickly, I met Nicholas, I think it was in 2014. We had a client, a fellow USC graduate who had been designated to a different prison. He was seeking to get redesignated, and Nicholas and I met through that redesignation process that was successful. And I think we're going on 9 years together now, Nicholas, with myriad clients together, including Joseph E. Gregorio, who's on our team. Joseph had, I think, a guideline sentence of 41 to 51 months, and Joseph got a year and a day. So Nicholas, welcome. Before we get into restitution, forfeiture, and those things, can you just give us a couple of minute summary on who you are and where you are, and as we begin to learn from you?
I've been practicing criminal defense law in New York City for more than 30 years. It's all about federal, and with the advent of the sentencing guidelines, it's all about plea agreements these days. Mostly, the trials are few and far between, but we just got off one in the Eastern District. There are some trials still, but it's all a guideline regime, as you know. And so all the nuances of restitution, mandatory Victim Restitution Act, and forfeiture and fines, it all goes into the mix. And we have been focused over the years with this kind of corollary of the financial litigation. Clients, since we're so good to our clients, they don't ever leave. And so we end up assisting them down the road when flu comes calling, or when we have to determine when the government wants to determine what's going to happen with some of their substantial assets, and they don't have substantial assets, how much they're going to be paying. And as you noted, once invariably they're off supervision, they stop making payments foolishly. So we've been practicing criminal defense, and this is just a corollary of what we do.
So when you have questions, everyone, please add them to chat or just do the Zoom hand, and I'll call on you. And let's just engage in an organic conversation. Let's talk about, I want to deal with some problems we receive. Defendants at times are obsessed with getting the shortest sentence. I know I was, but at times they don't understand the collateral consequences that follow, like money. When should someone know, Nicholas, that there could be a forfeiture or restitution? In other words, should that be in the plea agreement? Are they going to learn about it at sentencing? I hate when someone gets a call like, hey, I got a great sentence, but I owe $8 million. I had no idea. Help us understand the timeline.
It's always in the plea agreement. It would be foolish for it not to be. The court will allocate you as to the parameters of the agreement, and the court will say restitution, forfeiture are mandatory. Drug cases, there may not be forfeiture, but nevertheless, the court will invariably say, of course, there'll be court-ordered forfeiture. In this case, there may not be any because it's a drug case. So usually it's in the plea agreement, and you should, of course, talk about it with the client up front to let him know what's the nature of mandatory Victim Restitution Act. And it comes into play when the numbers are in flux. And as you correctly point out, the most important thing for many clients is minimizing their custodial term. And so we're not often focused on the number because a lot of times, it's just monopoly money. Who cares? But a lot of times the custodial term is driven by the custodial term is driven by the loss figures, and so is restitution. Restitution law is somewhat similar, but it varies. So we focus from our perspective on the loss for guideline purposes, but restitution always comes up. And sometimes we can separate those two numbers, believe it or not, where it's difficult to calculate the restitution. But I had a HUD case in the right before the 2008 meltdown, where an appraiser was involved in several hundred million loss, and all he did was get 775,000 for inflated appraisals. Well, we separated the restitution from the loss figures for guideline purposes, and that goes on somewhat. So
there's going to be a lot of questions to unpack there. Let's give a quick overview. There are some cases, white collar cases, like the Farmer Bro Martin Screwley case. There was both forfeiture and restitution, which in that same case. Can you just give a quick overview of the difference between forfeiture and restitution?
Sure. Forfeiture is intends to disgorge any ill-gotten gains a criminal defendant may have received by the fruits of his conduct. So if you're a stockbroker and $1 million comes into your possession, and you have $1 million, even if you don't have it, but it came into your possession, forfeiture is automatic, and you should be required to forfeit what came into your possession. That's ill-gotten gains. It's the fruits of your criminality. It's different. It serves a different purpose than restitution, which is to make the victim whole. So two different things. They can be both imposed in some circumstances for the same $1 million. You can have a $2 million obligation imposed against you. And while it may be monopoly money, for some people it's not. And of course, the judgment specifies which component should be paid first. Special assessment, fine, restitution, forfeiture thereafter if the person doesn't have enough money. What I like to do, talking about the interplay between restitution and forfeiture, if, for example, there are assets like jewelry or a house or some ill-gotten gains, the government will sometimes recommend and have it in the plea agreement that amounts forfeited may be remitted. That's a term of art. The U.S. Attorney's Office may recommend to DOJ that the forfeiture amount be remitted to pay the restitution in this case, which is wonderful, so you don't have a double penalty. And we've been successful with that sometimes.
So let's talk for a moment about primary residence, because some people freak out, like, my goodness, I own a home in part through some of these either restitution or ill-gotten gains, and they fear the government is going to put them on the street. In my case, I had restitution. The government put a lien on my home. The lien was for 20 years. I got a lien release from the Department of Justice in 2019 when my restitution was finally paid in full. But there are some people that freak out, like they're going to throw me out of my house. Have you ever seen that? And let's talk for a moment about the primary residence in your experience.
I haven't seen it with a primary residence. I've seen it with investment property. Usually they'll try to get you to sell it by putting the lien on it, and invariably someone will want to refinance or sell, and the government will want its cut. So, but I've never seen anyone thrown out of their primary residence, even if they're the sole owner, especially where they have a family. I just haven't seen it. But there's a lien on it for 20 years. In New York, it's a judgment against the property for 10, unless it's renewed. But it's a 20-year lien.
So that's important for all of you.
It's good for 20 years. Exactly.
Right. Now, there are a number of people on this webinar who have signed a plea agreements, and if you were to ask them on a scale of 1 to 10, do they agree with the plea agreement? Probably very few hands would go up. A number of people feel that same way about restitution, yet when I really tried to push back on my restitution, my lawyer, with whom I'm still friends, said, Justin, we don't want to push too far where it can begin to hurt you, because if you do, it might not look like you're accepting responsibility. And there are a number of people who have restitution orders, they don't feel as accurate. So whether it's your clients or people on this process, offer some advice on how they could advocate to at least try to get the numbers correct. Some numbers are so massive, but my number was 535,000. I'm convinced it really should have been 300,000, but we couldn't convince the U.S. attorney to remove another 200. I mean, that was a big difference for me because I paid it in full. How do you work with the government, and how can defendants advocate to make sure, like, this is as close as it can be?
There's been a lot of good law on this in the last 10 years, and the number should be netted out to amounts that have been recovered. And so you just engage in negotiation as part of the plea agreement. Oftentimes the government has their figures, but if you look through discovery, if you show the checks that went back to the clients, you can get that number down. So you just got to do the work. Before, it's always great to have a lower starting number, and if that's the Bible. Once it's in the judgment of conviction, that's where you start from, and then what happens years later is you deal with it. But you're right. Oftentimes people don't want to deal with it. They're more concerned about the numbers, and it's just monopoly money. That's most of the time what people feel.
In a little bit, we're going to talk about restitution and forfeiture post-sentencing, but I want to spend a few more minutes leading up to sentencing. Let's just say someone signs a plea agreement and there's a $2 million loss. And this happened recently with someone in our community. A physician in Mississippi paid $2.1 million when he signed the plea. All of the money's paid back. Does that change the sentencing guidelines, or does it stay the same even if the money's been paid back? Help us understand that.
The loss is the loss. It doesn't change the guidelines. That's what you intended to get or reasonably could have gotten. So the loss is a different calculus than the restitution. So completely different.
There are some people, and I have a number of opinions on this, I'm transparent, that my victims wouldn't want to hear this, but I paid $100,000 at sentencing and I regretted it. It probably bought me 6 months out of prison, but I was 33. I wasn't married. I didn't have children. I needed that money when I came home. There are a number of people who make a restitution payment hoping that it will keep them out of jail or lead to a shorter sentence. I think that's something you encouraged Joseph to do, which he did. If someone has some resources, even modest, do you see it have a measurable impact at sentencing by making a restitution payment?
I think it depends on the judge in the Eastern District of New York and the Southern where we are. I think it's incredibly important to come to court with something to show that you're serious, your remorse is real, and you're demonstrating that by coming to court with something. I don't know if you can quantify it into a term of months, but it's absolutely beneficial, I think. And you should put that in the plea agreement. Many courts say, I credit the fact that he's paid this. I believe I'm giving him a lesser sentence because he wants to pay this off as soon as possible. I want to get him working if he has the means to pay this. So I think it's helpful. But obviously, if you have the means, you can't sell your house, or maybe you can and downsize. If you're living in a mega mansion and you want to protect that, that's great. But the court will note that when people are out a lot of money. So if you come to court with a few $100,000 check where there's $1 million loss, I think that's incredibly helpful at sentencing.
And on the flip side, when someone owes a lot, we work with a lawyer named Alan Eisner here in Los Angeles. He had a client owed about $4.5 million in Medicare. And his client, Renee, I think it was like an $8,800 restitution payment he made at sentencing. What he gave relative to what he owed was nothing. But if you knew how hard he worked to save that, the judge appreciated that, even though it was symbolic. So it goes both ways. And we want all of you to consider that. Agreed.
And I know some clients have taken jobs at Amazon warehouses and they owe an incredible amount of money. But the fact that they get out of bed, they're just not sitting on their hands throughout the pre-sentence period. I think it's very important to come to court with something.
Work, everyone knows I'm actually my old business partner's home in Los Angeles, Sam Pompeo, who worked with me for 3 years before I went to prison. The reason I really got the shortest sentence is because Judge Wilson saw me working up to sentencing. You've got to build a new record. Joseph, by the way, worked at a golf course, worked at Amazon. It's part of the reason they won. It was 41 to 51. He got a year and a day. It wasn't by accident. Someone's asking about intended versus actual loss. Can you clarify what that means?
Well, for example, if you apply for mortgages in the amount of $5 million, that's your intended loss. The government will calculate all that. That could be all the loss for guideline purpose, but your actual loss for restitution purposes, say you paid back $3 million, your loss will be $2 million. It's fairly simple.
Got it. Okay. Now, someone made a comment that said that the government is, we want to be clear, the government is forcing us to sell our primary residence and make the proceeds payable to the aggrieved person. I don't know the specifics here, if they're really strongly suggesting or they're demanding that you pay. So I'll let you know, as Liz said, you might want to consider getting a lawyer, getting some help throughout that process. People are saying they took my house. So clearly, apparently these things can happen. Nicholas, as we get back to preparing for sentencing, potentially making a payment at sentencing, what happens with the judge? Is the judge going to apply like a restitution order, a payment while while in prison. Walk people through the actual, you get the number, and then I know there's this judgment and commitment order where the judge may talk about the fines and restitution. Help people understand what happens following sentencing if they have a restitution or fine.
Sentence will be imposed orally, all the details of the sentence. You should note that the sentence is what's announced orally, not what may later be on the judgment and commitment. So the judge will say X term of months, custodial term, $500,000 in forfeiture, million in restitution, to be paid at a rate of $50 a month while incarcerated, $200 a month, or 20% of his gross after he's on supervised release. And that will be reflected in the judgment and commitment, which will follow you throughout the BOP, your Bureau of Prisons custodial term. And it's important that what the judge ordered be paid. I think it's absolutely critical, as you, I'm sure, are going to talk about the inmate financial responsibility plan, that people get on that BOP program and pay what the court ordered them to pay quarterly or monthly. I think it's quarterly, because you get advantages of being on the IFRP within the BOP, whether it's early release or programming. Absolutely critical while you're in to maintain financial responsibility as ordered by the judge. You agree?
Yeah, I would agree. In prison, they'll probably put up signs that say FRP is due. And I know that we've discussed there are changes we think coming in prisons regarding voluntary versus mandatory. Remember, some senators went apoplectic when they heard that R. Kelly had $38,000 in his commissary account. They're like, why isn't this going to victims? So you have to understand budgeting in prison. If you, I remember one of my earlier clients had a 10-month sentence. He surrendered with $5,000. Like, they took 90% of it for his restitution because they thought he was flush. He's like, I thought I was just bringing money for my whole journey so I didn't have to burden my family. It's part of the reason people engage in the prison hustle and have money go to other people's books to bump up their commissary and have less on their own. So yes, FRP is important that you pay, should be built into the release plan and everything else that you're doing. At my sentencing, Nicholas, my judge said, and we'll talk about this, how it changed when I came home, Judge Wilson said 10% or $500 a month on supervised release. Is that pretty standard, those sorts of numbers?
10%, 15, 20 on gross, so 10% on net. I've seen it both ways. But I want to go back to a commissary account. I've had the U.S. Attorney's Office at least 2 times a year go to an inmate's commissary account if he has 2,000 or 3,000 in there, not in the Southern District, but in the District of New Jersey and elsewhere in the country. 2,000 or 3,000, that's fair game. And they'll file the motion and the court will generally agree with it. So please don't put a lot. Keep it under 500 and have your family periodically infuse the account. That's the best way to do it.
Nicholas, diving into the prison advice here. I like it. That was some good advice.
Sorry, but
you should. That's the right advice. I'm just suggesting you update your title, lawyer. That was perfect advice. Please don't put us out of business. Don't do any more of that, please. Please, that's enough. That was fantastic. Okay, people are asking questions about. Before we get into post sentencing and how the flu likes to come and continue to create crisis and stress for us. This is a question that's very important. It comes up a lot. There are so many coming in. I'm part of a PPP case where there are 30 people involved and more than 2 million in loss. I'm being told I'm responsible for all of that debt along with the other 30 people. Can that be negotiated?
You know, it's joint and several liability. Your lawyer may be able to. We were in a Medicare fraud case where there was like 2 million in loss, and our client was a driver, and we got the government to agree that his loss and restitution figures were only represented by the bills that were put in using his driver ID. So a lot of times you can reduce it to less than the overall scope of the conspiracy, depending on his knowledge of what other people were doing, lack of knowledge, what other people were doing. So yeah, you can negotiate that down before the fact. After the fact, it's written in stone.
That's a very important part. It's written in stone. And there are people in this community who will reach out and say, I was just sentenced and I owe this money. I had no idea. And it's devastating and can't undo it. It's just like it's nearly impossible to change a probation report once completed. We can't change the past, which is why we're doing this. Someone asked, my co-defendant has agreed to forfeiture in an amount that covers more than the entire loss. How do I check to see if any of it will be remitted towards restitution?
The flu financial litigation unit has a spreadsheet on every defendant, and they show on every case how much has been applied for restitution and for forfeiture. And so you can get it from the financial litigation unit. That's the first place I would check. Of course,
Okay.
you may not want to be on their radar. So sometimes it's reflected on the docket sheet if payments are made directly to the court. So
Yeah, I'm not a huge proponent unless it's necessary of reaching out. There are some people in prison who are like bored and they're like, hey, how much has been applied to this? And it's like waking a sleeping giant, just like that. They're like, oh, thanks for reaching out. You're curious about how much
never
has been
poke the
paid.
bear.
Yeah, it's insane. Okay. Now, do
Agreed.
you have any idea? There are some victims because of our presence on TikTok and YouTube. Some victims will call, some are nice, some are angry, not our victims, victims of some of our clients, and they'll say, hey, I know the person who victimized me has made like a big payment, but I haven't gotten the money yet. Like, why isn't the Department of Justice sending me the money? And sometimes when victims don't get their money, they can continue to hound the government to go after that person. Do you have any idea how long it takes the victims to begin to get this money once payments are made?
I just don't. I have no idea. So kind of outside my end. So sorry.
I know in my case, it took someone more than a year to get to get money that was contributed. And if it's about the victims,
I have seen periodic payments like yearly. That's what I've seen, but that's just one time that I saw it.
all right, I'd like to transition into post-sentencing a little more. We talked about prison. Before I do, Nevin, your hand's been up. Please ask a question to Nicholas about restitution, forfeiture, and then we'll continue.
Yes, thank you. Hi, Nicholas. Thank you for sharing your time and your insight. If the defendant has not received any proceeds directly or indirectly as a result of the offense, can the government still seize the defendant's assets by forfeiture? And I guess during the plea negotiation, will you try to advocate to have the forfeiture language removed from the plea agreement or have it stated as the forfeiture is zero?
I think there are multiple bases for forfeiture, and it all depends on the facts of the case, whether it's 982 or it's very complex. But if he didn't get it through his hands, they can still absolutely order forfeiture in the case. Absolutely, he doesn't have to have received it. He can be, and if he doesn't have it now, there could be a substitute asset provision, obviously, that they can forfeit. If you once had it, but you don't have it now, they can go after substitute assets. And a lot of times that's in the indictment. And I don't know that it'll probably be in the forfeiture order. So,
But even if the defendant did not receive anything directly from the stated crime.
I think there can be if he didn't receive it directly. Absolutely. But I want to look at the circumstances. It's a little hard to make a blanket statement like that. Generally.
No, yeah. I appreciate that. Thank you.
Nicholas, I want to talk about spouses for a moment and share a story. In 2011, I spoke at the FBI Academy and I was getting a tour of Quantico, the FBI agent who arrested me and was giving me the tour. I said, what are the two dumbest things you see defendants do? He said, well, you did the first thing, which was lying to us after we were after you. I said, okay, what's two? He said, I love it when defendants who are married fake divorces simply because they think the divorce is going to lead to us potentially not getting income from the spouse or now the ex-wife. He said the best part is when they still live together, but they claim to be divorced. Can you just talk about the spouses and how impacted they could be if they weren't part of the crime? And in your experience, how aggressively the government could collect? Just talk about the spouse dynamic for a moment, if you would, because there's so many variations.
I haven't seen fake divorces.
I've seen about 50 of them in the last 10 years.
Wow, that's pretty cold. But I understand when dollars are involved. But spouses, obviously, they can't collect from a spouse. They can't collect a spouse's income, but they can look. Financial Litigation Unit, and the government and the judge can look at the spouse's income when determining the rate of payment of restitution. So, for example, I had a client very successful in that HUD fraud I was talking about.
Yep.
He and his wife, but in his wife's name, built up a hotel on a very successful hotel in the 10 years after the 63 million in forfeiture was ordered, and he just sold it for 13 million. And the government came calling, and they've been battling for years, looking after his properties, his wife's properties, because he did business in the wife's name. But she was a very intelligent, very successful woman in her own right, but he did it right. He put her on all the paperwork. She was listed everywhere as the owner. So Divorces, I don't know about, but if you think you're gonna do it only, just put something in your wife's name, but you're really the manager, the government will see through that in a minute. So if you really want, it's like the WBE or the MBE contracts, women business enterprise. You really just can't have a figurehead. They really have to be the owner of the business. So
What I was advised to do when I got married in 2013, because I was a little older, my wife came to our marriage with assets. We were advised to get a post-nuptial agreement, which we did. I don't even know if it helped. By now, restitution is paid. Also, for many of you, as a consequence of my owing restitution, the home that my wife and I owned at the time, my wife bought on her own and qualified for. Didn't mean there weren't ways that I can contribute to it and make her and help, but the title was in her name. And the downside was we couldn't get a bigger loan because we were only using her income, because if I went on the title, the government was going to put a lien on it. These are sort of the consequences that follow. Then when it was paid, we bought a new home. Thankfully, we're on that together. So these are just some of the inconveniences that follow post-sentencing. I want to continue, but I do see.
but like I said, before you move on, the government put a lien on the sale of the hotel, even though it was all in the wife's name, to get our attention, even though we've been battling for 17, 18 years, and they got their cut. They got a little cut, like, I don't know, 10% of the proceeds of the sale, even though nothing was in the client's name. So
It does require.
obviously you can minimize. Post-nuptial agreements are great. I like it.
Yeah, years ago, I had a case with a lawyer you probably know in Connecticut, Jim Glassner, whose father was a federal judge in New York, and a client sold a home and they tried to take all the proceeds, and half of the home was his wife, and it took a few months to figure out, but in time, the defendant's proceeds went to the government and the wife was able to keep the other half. So it kind of requires advocacy and fighting and planning, just not rolling over it. It's a lot of money and your spouse didn't do anything and shouldn't be held more culpable. Now, in a little bit, I will discuss ways where the government can go after you if you're claiming you cannot make a payment if you're not working and your spouse is. For now, let's engage our community. Mark Fitting. Mark, Nicholas Mark was sentenced a few weeks ago to 41 months in federal prison, worked for the Department of Defense for a long time, really active in our community. Mark, we're grateful to have you. What is your question?
A couple of things. First, I wanted to ask about children that are out of the house, and adult children. Basically, is there any way the DOJ can go after them?
No, you're not responsible for your the parents' debts. So can't be criminally prosecuted for something a parent does, or, no, absolutely not. Now, what if you gave assets to your children, forfeitable assets? Can the government go after those? Yeah, absolutely. But for your judgment, a judgment against you for restitution, they didn't receive anything, I don't see that happening. Did they get an education? Were they going to recoup the education that you provided to your children? I don't see that happening.
Thank you.
And you also mentioned that when the judge sentenced me, he didn't talk about forfeiture or restitution, other than they did state that the restitution was paid in full by one of my co-defendants prior to the sentencing. But I paid most of my forfeiture, but not all of it. But it wasn't mentioned at sentencing. So is that going to be in the statement when I get it? I haven't received my written statement of reasons or whatever from the judge yet.
I don't know if you get your statement of reasons. Some jurisdictions give it, some don't. Am I to understand you paid some forfeiture and a co-defendant paid all of the joint and several forfeiture? So that means more than one forfeiture was paid. I don't know. Maybe, will they apply some of it to restitution in that case? I don't know. Interesting.
Well, to be clear, it was separate forfeiture and restitution, and the co-defendant paid the entire amount of the restitution that was joint and several. But I had a specific money judgment against me that is not paid in full yet.
Okay, so what's the question?
So I don't they didn't say at sentencing how much left I have to pay. Like, I think I know what it is, but is there going to be an order issued against the rest of that money?
There has to be an order of forfeiture. I mean, that's from where the forfeiture payments will spring, the order of forfeiture. They can't collect unless they have an order. And they have, what, 90 days, I think, to enter that? Unless there's an extension.
So if I don't receive something in 90 days, then I'm good.
I don't think you're going to be getting forfeiture. So
Okay, thank you. Thank you, Justin.
Yeah, you're welcome. Let's go through some questions and then we're going to continue. We're really getting engagement here, which is great. Someone asked about question, unmarried couple has a joint checking account, understandably would be subject to reporting the flu, looking at the activity or taking funds. Are the individual accounts or the other person then subject to reporting or scrutiny? They don't live in the same household.
So there's a joint checking account of people that don't live in the same household, correct?
Yes.
I don't know. Do you have control over it? Do you have effective control over those assets?
I
mean,
think so. As I understand the situation, the person might be in prison. The girlfriend or couple person is now out. They're not living together, but she might be managing some of those financial affairs.
Tough to say. I mean, if you're a co-owner of an account, you're entitled to the whole of the account. You can take all of it out. And so I'm imagining the government can levy on the entirety of that account. Yeah, there's an equitable argument that they're only entitled to half, but I think they're entitled to that account. Absolutely. If your name's on it, are they entitled then to go after the person who is the co-signer or the co-owner of that account? Well, they could do a subpoena in aid of enforcement of their judgment. They could do it in the flu form, the financial disclosure request that they ask you to fill out and sign once you're out. Sure. So they can go after everything.
All right, we'll get to some hands here in a moment. I want to address something that comes up a lot, which is, and I know you're not an estate lawyer, but inheritance. Someone owes $3 million in restitution. Parents are getting older. They may inherit some money. What advice or suggestions would you have for those clients or someone who may inherit some money and they owe money?
I don't do estate work, but generation skipping transfer perhaps, so that they name your children so it never comes into your hands. Absolutely, it's probably the best advice. Not as an aid to frustrate the federal judgment, but as an estate planning device. That's your intent behind it. So, but it also works to keep the money for your children rather than going to the government coffers or victims.
And that leads to where we'll transition to in a few minutes, the financial litigation unit and the questions they ask about inheritance and family and kids and everyone who has money. Before I do, let me get to a few other questions. Hands, Joe Toro, if you could lower your hand. I see iPhone 11. I don't know if that's your name, but iPhone 11, we'll call on you in a moment. Joe, what is your question? Great to see you, Joe.
Hey guys, how you doing?
Good.
Quick question. Does this apply to, let's say, for example, my girlfriend, me living with my girlfriend or moving into her, home after, I come out of prison? Can they go after her bank account and look into her assets because I'm physically living at her home?
Absolutely not. They can't get at her assets, but if you're living with someone, they can look at what her assets and her income is in determining your rate of payment, how much you should pay per month. So they can't get at her assets. Absolutely not.
But before we continue, let's knock out some of these questions. Let's go to iPhone 11. If you could lower your hand, then we're going to go to my friend Nikita. Let's go to iPhone 11. iPhone 11, we need you. Okay, let's go to Nikita.
Yes.
Go
I'm
ahead.
sorry. Can you hear me?
Yeah, let's go.
I just had a question. My judge didn't order a payment or any type of for my restitution. So who decides how much I pay? Would that be
It should be on there, but if he didn't order it, it's due in full. So that's the best answer I can give you. It's due immediately if he didn't order a term of schedule of payments. I'm sorry to say, but they can't get it from you in full. So, they're entitled to go after to try and get it somehow through state collection efforts, garnishing of wages, putting a lien on. So that's the best answer.
okay? Thank you.
I will tell you, there's someone in our community right now who's been off probation for several years. We're going to talk about more of this in a moment, and they're kind of going after him. He's got some resources and a lot of it in a retirement account, and this financial litigation unit is working with him to actually kind of forfeit and take the retirement account, which will save him the penalty because he's younger than 59 and a half. If you take money out of a retirement account beneath 59 and a half, could be a 10% penalty. So they're kind of bypassing that and going directly to get the money, which is going to save him some money, and that will pay his restitution full. And they offered that to me as well. They said, if you can't pay, we'll seize or take your retirement account and do so in a way where you're not going to have to pay this penalty. So there have been people who are like, they take it, they pay, you get hit with the income tax, but also this fine as well. So this is the value of good planning. Let's go back to Nikita, and then I want to talk about life after prison and dealing with restitution. So Nikita,
Before you move on, Justin, just 1 minute. I mean, everybody thinks 401ks are sacrosanct. IRS, government restitution and forfeiture is super tax lien. So they're not safe. So they can take IRAs, they can take 401ks, plenty of law on it. So everybody thinks they're sacrosanct, but the government gets at them, but they're willing to work with you.
That's true. And also one thing, Nicholas, I wish my lawyers had done at sentencing was not ask that interest be applied on the restitution, which it was at 1.66%. And do you ask judges not to apply interest on the restitution? And if you do, are judges open to it?
It's a little petty because federal interest is so low. And if it's monopoly money, it doesn't really matter. But sometimes I ask it, and sometimes they give it. It all depends on the circumstances.
Right, got it. But there isn't really downside in asking if the defendant's already been sentenced. It's not like the judge is going to say, I can't believe you've asked, I'm going to give you a longer sentence now.
No, that's what we're paid for, and we do it, absolutely.
Okay. Nikita, your question, please.
Yep. My question is in regards to if the government wants both restitution and forfeiture. In the case that the crime happened years ago, you have nothing to forfeit or very little. How does the remaining of what you owe for forfeiture, how does that work after you've been sentenced? You go to prison. Do you also make payments on the forfeiture amount and the restitution amount?
Usually you won't be able to pay both at the same time. And so restitution takes priority over forfeiture. So that's what would happen.
Okay, and is there like a carryover after you finish paying restitution? Do you need to still pay what they asked to forfeit, or how does it work?
If they're looking for it years later, they're more active on seeking restitution. Flu takes a lesser position, I think, with forfeiture. You don't see it all that often. They want people to get their money.
Understood. Thank
I'll
you.
go to thank you, Nikita. I'll go to Tony in a moment. If you could lower your hand. Before I do, I don't want to spend too much time on it, Nicholas, but I'd like you to talk about, I have found the IRS to almost be more aggressive in collecting than even flu. Anyone that might have tax issues, an IRS type case, quickly your experience in the IRS collecting versus flu, or, if you have any thoughts on that.
Absolutely. I mean, it's great. I mean, it's not great to have a tax lien, but there are things that can be done. You can go into uncollected status where they write it off. If you fill out a financial form that you just don't have the assets to pay it, you can enter into a payment plan. So there are lots of things that can be done with the IRS. Both in the payments and the total amount due. So there's a lot more latitude.
We had a client who paid $3 million to the IRS at sentencing, and it took about a year or two, but they hit him with a 75% penalty. Now he's got to pay that too. I mean, the IRS, they're ruthless.
That's
Terrible.
true. It should be worked out beforehand. No doubt about it. Shouldn't be paying the IRS without having an ironclad deal in hand.
Yeah, that leads into a separate discussion of some lawyers would argue, lay low, maybe they won't come after you, maybe they will, and just sort of hoping, rather than kind of like, we shouldn't poke the bear, but they tend to like to get the people that have resources. Let's go to this double dipping idea. I had restitution, and the SEC, I was due to have a $350,000 disgorgement with the SEC, but after they didn't think I should get sentenced to prison, I did, and they agreed not to collect. So do you see that? You got SEC, you owe money, civil, and then restitution is as well? Or are they really
The SEC
actively going to collect while you're paying restitution?
Sure, the SEC orders disgorgement, which is really the same thing as restitution. So they're not going to double dip in that regard. And in fact, I think it was in Joe's case, the SEC just went along and adopted the federal restitution order. And the case was held, we were stayed during the pendency of the criminal case, and then we just cooperated in the entry of their order, which was adopting the federal restitution from the criminal case.
Okay, so we're already at 10:40, everyone. We could talk about this for hours. We won't. Let's talk about coming home from prison. There are more questions and comments we'll address. I know when I came home from prison, I met my probation officer, Isaiah Murrow, in the halfway house. He gave me an updated financial packet to fill out. I did it. I did not find it to be as comprehensive as I eventually got from the financial litigation unit. I filled out the information and he said, I'll assess a payment plan for you once you start probation. You're going to pay based on how much you're making. So this might be some good news for all of you. When my judge said 10% or $500 a month, I'll tell you, Nicholas, for the first 3 or 4 months of my probation, I was only paying $100 a month because very little was coming in. So can you confirm? I guess the judge might give a number, but it's really it's up to that probation officer when you come home to reassess how you're doing financially.
Yeah, I agree with that completely. The judge can intend that. That can be the maximum, but if you're not making it, they're not going to put you back in because you're not earning. But you have to show that you're trying to get a job, you're trying to pay it back, and they'll assess. And please, whatever you do, cooperate with probation. They're kind of like the gatekeepers on all this. You don't want to get on the bad side by failing to pay. They work hand in hand kind of with you to try and they just don't want people to reoffend. They're not so much collection people, but they want to see something.
Right. And they can be off-put if you're spending big on probation. I was called back in front of my federal judge who sentenced me because he thought I was overspending on my credit card while trying to build this business, and he reined in my spending. So they're watching. You have to be honest in these monthly activity reports. When they pop into your home, they're looking to see if you have new assets, perhaps you bought and didn't disclose, things of that nature. So they're always watching what you're doing. Nicholas, let's continue with federal probation and heading towards the financial litigation unit. Is that separate from probation? Help us understand FLU in your experience.
Financial litigation unit is a department of the U.S. Attorney's Office. They're involved in civil litigation to collect, enforce judgments imposed in the criminal case. And they are the ones that monitor these thousands of cases for the last 20 years. If a judgment's good for 20 years, they must have this docket of however many indictments or criminal cases there are and other cases, and they have to collect on them. And so if you're paying your $100, $200, $300 a month, you're on that list and they're happy as clams. People invariably, I can't tell you how many times I've seen it, stop paying at the conclusion of their supervisory period. And that will get the attention of the financial litigation unit, and you'll get the dreaded packet. Dear sir, you're still represented by counsel. Have counsel call us, but in the meantime, please fill out this financial disclosure form, which is like a proctological exam. It is so thorough. It's more thorough than the probation report. They want to know everything. And so when they get involved, you have to show what you have coming in, what your assets are, and they're going to recommend a number that you pay. And you can agree to it, you can fight it. I fought them at hearings before federal judges, and in the end, it's best just to agree with them. But you have to make a reasonable number that everybody can live with. That one case, they wanted something like $10,000 a month from my client, and it was just unsustainable. So we just strung them along for many, many years. And ultimately, as I said, he and his wife sold the hotel and they got a big chunk of it. So not a big chunk, a small chunk, but a lot of dollars. So FLU, lot that we can say about FLU.
When I was done, I finished probation August 16th of 2012, 45 days later or so, and I'll put up the letter in the replay, the actual letter I received from, it was the probation office that said, you have completed your term of supervision, but you have a continuing debt to the United States government, continue to make payments. So I continue to how I ended probation. So by that time, I was thinking like $500, $1,000 a month. I was pretty strategic on probation when I was making.
Your mic's cutting out. We can't hear you.
Oh, I don't know why. Can you hear me? Are you with me?
Can't hear you. Can anybody else hear him?
I don't know what happened. Hold on.
No.
I don't know why. 1 second.
Justin?
Can you hear me
All
now?
right. We can hear you now.
Okay, I took off my, okay. Am I back? Am I okay?
You're back?
Thank you. So I continued, I paid more on probation when I could. It gave me more liberty on probation. He allowed me to travel more. So if you can do it, it builds goodwill. But I did get that letter from probation saying that I owed money. Nicholas, you touched on this for a moment. Some defendants, they're done with probation and they're like, hey, I'm good, I'm done. In my experience, they'll kind of make the same payment for a month or two, and then they'll skip a month, then they'll get back on track half as much. Then like, hey, I'm going to test not paying for a couple of months. And like, hey, I think they forgot about me. And then it could lead to that dreaded flu letter. So you would confirm that people should continue to pay.
It's so much more costly to not pay. It's going to come back. It's going to bite you in the ass. It's cheaper to pay. It's so much cheaper to pay. Never poke the bear, and you poke the bear by not paying.
Right. Now, you can, that's exactly right. You continue to pay. Have more thoughts on this, Tony? You've been waiting patiently. Tony Gugliotta, if you could unmute yourself and ask your question for Nicholas.
Yeah, so my mother set up a trust. She's older, and I actually reside in the home that she and my father used to live in, and I've been paying basically rent to her for several years. My children and I live here. And so her concern has been when she passes, she set up right of survivorship of the house, but she also has a trust fund that is supposed to handle emergency and health expenses for me and the kids. I told her it'd probably be better to just put it in the beneficiaries of the trust in my children's name rather than mine. She spoke with an attorney who said otherwise, and I just like some feedback on that.
I think the only reason the attorney would say otherwise would be maybe the tax consequences, or maybe to give control to children who, may not be sufficiently mature. That may be the reasoning, but I would think you would want to do everything to keep it out of your name. So that's the general overview.
Okay, thank you.
Thank you, Nicholas. I'll tell you, for those of you who come home and might not work and have a spouse that works, we had a really unfortunate situation years ago where someone who came home, he was very rude to the probation officer, like, hey, I don't have any money, therefore I can't pay restitution, get off my back. And that really went in the wrong direction when the probation officer asked questions. Do you live in this home? Yes. Does your wife have a job? Yes. She had a very successful mortgage business. Did you eat any of the food your wife buys at the store? Yes. Do you benefit from the gas that she buys and puts in your car? Yes. Okay. The probation officer said, so you can benefit from everything else your wife makes, but she can't contribute to a restitution payment. It was awful. It was foolish. And it set up a terrible tomb of supervision for this person only because he thought because he wasn't making money, he would pay. Short-sighted, foolish, dumb, be different from him. I want to continue with some gossip we hear in prison, Nicholas, about settling restitution and forfeiture. Before I do, I still see hands up. Nevin, if your hand is still up again, is that to ask a question? If so, let's hear it.
Hi, Nicholas. You mentioned the restitution order could range from 10% net to 20% gross. Obviously, that's a material difference in the defendant's well-being long-term. Is there any strategy to advocate for a 10% net restitution order compared to?
I don't know. Judges have their own preference, and it varies by district. So I prefer, it's easier to do 20 gross. That's what I've seen most of them do. 20% of your gross, but obviously we'd much rather pay 10% of the net. I mean, that's a much less number, right?
Yeah.
And I don't know, maybe I misspoke. Maybe it's 20% of the net or 10% of the gross, but I think generally it's 20 of the gross even. That's the higher number. So,
but can you advocate? When do you advocate for that? Is it just at sentencing, the lawyer stands up and asks for it, or is it part of the plea?
I mean, I think it's usually in the pre-sentence report what the recommendation is, and so look at what they recommend and I talk to the client about it beforehand. And I mean, if you're in, you can't argue, well, I'm not making anything, and we have to balance. What are we looking for? Are we gonna quibble about the rate of payment? Not so much usually. It's not such a big deal as we're trying to get the term of years down. So
Got it. Thank you.
So I want to talk about some of the prison gossip that people who have yet to go to prison will hear. Someone comments, my husband has been in custody for 3 years, then sentenced to prison, sent a demand letter for $8 million. Why would they do that when they know that he's in prison? My response, I think it's automatic. They just you come up and they send it to you. Sometimes you don't know, but how would you respond to that, Nicholas?
they're going to send a letter, and they might even put a lien on the property they'll file a lien with the clerk's office in the county where the person lives, referencing that address that he doesn't own. And people often get frightened. Oh my God, there's a lien on my wife's home. But it doesn't operate as a lien on the wife's interest in the home. It operates as a lien on the husband's interest in the home, but he has none. So they do that. I don't want to say they do it to shake you up, but they do it to protect themselves. So, but it gets people's attention, that's for sure. Now, you touched on, can it be compromised? It can't be compromised. The number can't be, but sometimes when you have a big asset and you settle with them after dealing with flu, dealing with depositions, dealing with liens. This hotel that I said that the client's wife started was sold for 13 million, and we settled with flu to give the wife contributed 500,000 from the sale price of that hotel. But now I still advise him to continue making $600 monthly payments, although he's going to be retired. So at some point, there are multiple properties, but it's kind of like a settlement. It's a silent settlement in that they're not looking at all the other properties arguably he or his wife owns. So we made a lump sum settlement, and we have peace for the next 4 years, as long as the remaining left on the judgment. So that's the best you can do in terms of compromising the number. Settle by pay them a good chunk, and you have peace for a few years.
I want to talk about options when you receive the flu paperwork and what people do. You get the packet. I received it probably every 18 months after I was done with probation. At one time I found it so inconvenient, I actually picked it up and I threw it in the trash. And then I didn't hear from them, ironically, for about 3 years, though I continued to make monthly payments. And my thoughts at the time were, maybe I was just having a bad day. I was frustrated. I'd gotten it so repeatedly. I felt like anytime they saw me on TV, they put it in the mail and sent it to me. And then 3 years later, and I told myself, they didn't serve this with a subpoena. How could they prove that I got this? This is how I rationalized it at the time. It came in the mail. I threw it away. I know people do that. I wish I hadn't done it. I did that one time. Let's talk about something that's on those flu forms. You were signing this under penalty of perjury, and that convinces some people to freak out because on that form, they're asking for spouse, kids, inheritance. Some clients are like, I'm not giving them my spouse's information. I'm not going to do it. Should they leave that out? Could the government then go and subpoena the wife? Help people understand, if they're going to fill out the form, which you should do, how they should respond to some questions they might not want to give that information.
That's a great question, and you raised a very important issue of it being signed under penalty of perjury. So what, of course, all of us know is any false statement there is a violation of 1001, and you could be prosecuted up to 5 years, in jail for a false statement, a material false statement, which statement minimizing your assets would be. So I often get this, I'm not disclosing my wife's. And so what they do, and they have done, is they'll depose the wife, or they'll send a subpoena to the wife to find out about the wife's assets. And they're doing this to aid in their enforcement of judgment. So it's difficult to swallow that you have to disclose your wife's assets. But I generally think you should, but you can engage with an attorney and push back a little. And do you want to be cute? Do you want to be cute? The government will get cute and give a notice to depose her if they think there's something there. And if they think there's something there, I bet there is. So, but if there's nothing really there, then why not disclose her assets and her bank accounts? And so that's where we are. They're going to use that to determine what you can pay. Household income.
I'll get to some questions. I want to talk about how to respond to these. When the Department of Justice sued me in 2019, I was irate because I made so many payments, never missed a damn month. And I called Bob Lester, who worked at the Financial Litigation Unit, and I said, why? I've never missed a payment. Why would you sue me? And I've documented what he said to me. That was probably wrong, right? I should have reached out to a lawyer like you. I ended up working with a good friend, a lawyer here in Los Angeles, Mark Worksman, ended up calling the Financial Litigation Unit to help me. But if someone gets that lawsuit or they get that letter and they're unsure how to respond, they shouldn't reach out to them, right? A lawyer should reach out on their behalf and say, let's talk about this. Would you agree with that?
Generally, yeah, but sometimes where I represent like a worker who just is a truck driver and, his assets are pretty clear, I'll say, look, just fill it out to the best of your ability. Do you have any undisclosed, anything I don't know about? Are you hiding anything? I mean, I hate, and I'll look it over as a courtesy often, but I don't want to be retained where the person really doesn't have much and what they have, the government wants to get. So, but if it's a more sophisticated type thing, I think counsel should work between the client and FLU. You don't want the client to make any statements which could be used against them. And certainly you want to vet the FLU financial disclosure form for accuracy. If it's written and he swears to it, that's a problem. And if it's wrong.
I want to talk to you in a moment about prison gossip and what I heard in people here. In my case, everyone, I still had about $200,000 outstanding. I settled with the Department of Justice to pay the $200,000. I did a lump sum of 150, and they allowed me to pay the balance off over 12 months. And the balance over the next 12 months, they stopped accruing interest at 1.66%.
That's great.
Yeah, Mark did a great job for me. I was very grateful. In prison, you hear a lot of guys who will say, yes, I owe $75 million in restitution, but when I come home, I'm going to settle for 3 cents on the dollar. It's hilarious, and guys believe it. Have you ever seen settlements like that? You owe 10 million, I'm going to send you 2 and we're done. Help us understand.
It's not lawful. It doesn't happen,
like that.
and there's no legal basis to resolve to compromise the number. So it just doesn't happen, and it can't.
Guys, any of you going to prison, if you've been to prison, you've heard it. It's just ridiculous and insane. I heard it too, and I got super excited. Like, wow, I owe 500. I'm going to settle for 50. It turned out not to be true. Okay, I see some hands up. Nikita, is your hand still up? Did you have a question again? If not, let me go here.
No, sorry about that.
Don't apologize. It's fine. Someone said also after probation, can you pay your 10% of gross as ordered by judge as a one-time annual payment, even though government does not account for payment and will not be distributed by 12 months? Is there a different way of paying monthly in a lump? This comes up a lot, especially for entrepreneurs who may come into a big chunk and nothing for several months. I always advise just keep paying every month. What would you say?
I absolutely agree. I have clients say, but that's not how my business works. It's feast or famine. I say, look, get a payment, get a number, stick to it. I don't care how you do it, but monthly is so much better. Then what? You're going to be partners with them. You're going to be telling them, showing them what you're making on a specific deal. You're going to be showing them checks. It's ridiculous. So get a number, stick to it.
Yeah, I would agree with that. And it's very freeing to have it paid off. For some of you, I know it's not possible. So I encourage you to be very long-term thinking. If your payment's $200 or $300 a month and you have a good month, and if you send in 500 or 600, I'm telling you, you stand out. You are different from everyone else who complains about making payments or who pays the bare minimum. Find ways to stand out. Nicholas, we're going on.
Let me note parenthetically, which we didn't discuss during the pre-sentence context, well, in the supervisory context, you're not going to get off supervised release unless your restitution is paid in full. So people like to say, oh, I'm going to terminate it after 1.5 years. If I have a 3-year supervised release term, if your restitution isn't paid in full, you're not getting off. So I just wanted to address that, and I'm sure you'll agree.
Yeah, it's very hard. In fact, I only know of one person, Dr. Nate Schott, who's been very active in our community. Dr. Schott was a dentist from Tennessee, and he got 36 months at Montgomery. He got home in about 10. And he got off after 21 months despite owing restitution. He's very persuasive and a good salesperson, but also compliant. Okay. So that's one person. But look, you know, our team's personally guided like more than 1,000 people. And when you hear one, odds are it's not going to be likely. It doesn't mean, however, you can't have more liberty by virtue of your plan and making payments. We've had people leave the country on probation. We've had people get more permission to build their own business if they're making payments. So
less likely to approve international travel or go on a cruise if you owe a gigantic number.
I had a speaking event in Europe that Judge Wilson wouldn't approve because I still owed money. And it was also a paid speaking event for KPMG, but it was because I was out of the country and I owed money. Those are very good points. Okay. As we're wrapping up here, Nicholas, at 11, I want to be respectful of your time. Let's wrap this up in a few minutes. Someone's asking, I can get a passport on probation if I don't have restitution or forfeiture. Yes, you can.
Absolutely. Yeah, absolutely.
Someone, let's see, are there any other, there's been a lot of comments here. Doesn't mean we can't bring.
You're cutting out again. Cutting out. Can't hear you. Nope.
The balance of the webinar, if I don't.
There it is.
All right, you're back. You're back, Justin.
Someone on my team, if that ever happens again, Scott or Patty, just or somebody else, jump in and let's finish this conversation. You all know this as well as I do. Okay, just jump in and take over for me. We're at 11 o'clock, Nicholas. I want to be respectful of your time. Are there any other final thoughts you have on restitution and forfeiture? I know this is an important topic. I'll put up the replay. More questions will come, but we're grateful that you've given us an hour. I'm sure you're back in court or something.
No, I'm not, but I have as much time as you want. But overview is, address it beforehand through the discovery with your client, with the prosecutor, address it with the court through the probation. Get the numbers set beforehand as good as you can get them. And if you have to trade restitution for time, I think everybody would love to do that. And so if you have to come up with something at sentencing to lower your custodial term, I think that's great. Pay what you can, get in the inmate financial responsibility, just pay the minimal, I don't want to say the minimal, but pay something to show you're making efforts, strides to repay what you owe, because this is a debt that you owe to victims. If it's restitution, you owe it as disgorgement, if it's forfeiture. So make an effort and don't throw it in the garbage like you did.
I want to thank you. And I want to close with not overselling if someone makes a restitution payment. I've been to some sentencing hearings, and that actually happened with that doctor client in Mississippi. He paid back all of the money, but he oversold it to the judge that he paid this money back to the point where it almost began to work against him. Is there a bit of a good cop, bad cop? You as the lawyer kind of sell, he paid back the money, Your Honor, he cooperated. These are important mitigating factors. And we would argue the defendant should be more deferential and honest, and I accept responsibility. I'll never return. Have you seen some people try to oversell the fact that they're making a payment at restitution, or is that something you're supposed to do as lawyer? I think it's a fine balance. It pissed this judge off is what I'm telling you.
I agree, but it is always better in my mind to stand before court where the victims have been repaid from my perspective. So, I mean, the client shouldn't adopt it as part of his statement and say, oh, well, everybody's been repaid, so, I'm a saint. That's the lawyer's job to do. And every judge I've ever been before really significantly appreciates it when when victims have been compensated in full and there's no real loss. So that counts heavily, in my opinion.
One more question before we wrap up, because I got a text from someone who's at work, his spouse. We have someone who is a white collar executive serving time in a low security prison, short sentence with restitution. He's due to be deported. This actually just came up as well in the comments. It's ironic. He's looking to get deported back to South Africa. What happens with restitution if someone's going to get deported? Do they keep him here while on probation to try to collect? Walk us through the deportation aspect if you owe money.
Deportation is going to take precedence over his financial responsibility, no doubt about it. There's actually a device called non-reporting supervision, and that's for people who, like mules, they get deported immediately, but the court seeks to impose has to impose a supervised release term. Well, you can't be on supervised release if you're back in the Dominican Republic. So they're going to be deported. Restitution will be of no consequence at that point. If he has assets in the country, maybe, but I don't think it'd be an issue.
Excellent. Nicholas, this was a wonderful webinar on restitution and forfeiture, incredibly valuable. We're so thankful that you've contributed. I will put in the school replay webinar Nicholas's contact information if you have questions or you're in New York. I know several people on this webinar have worked with Nicholas, including Joseph. He's a terrific lawyer and friend. And Nicholas, we're grateful you've taken so much time today.
Thank you. Thank you, Justin. It really was a pleasure. I think what you guys do is just fantastic. It takes some of the mystery out of what's going to unfold for many people. And it's a solace, and I hope it's been informative from my perspective. It has been informative from my end. So thank you.
Thank you for that pitch. We're grateful. We need it. Thank you. Okay, everyone, we'll see you next Thursday, and we'll see you inside of the school community. I'll put up a link to Mitigation Arc if you want to dive into that mastermind with Michael. Thank you again, Nicholas.
Thank you.
Okay, bye-bye.
Bye, guys.
Bye.
Thank you.